Hi, everyone, and welcome to Pastrami Law Melt, making the law easy to digest since 2022. My name is Brian Pastore, and I'm a trial lawyer in Southern California. During this podcast, we're going to talk about the infamous McDonald's coffee case. But what I want to do in this podcast is talk about the case from a trial lawyer's perspective, as well as go over the things that lawyers know happens in a case, and like the McDonald's coffee case, but your average person might not know is actually going on in the background. This is all meant to be educational, so as the standard lawyer disclaimer, if you think that you do need legal advice, make sure that you consult an attorney who's licensed to practice in your area. So with all that being said, today I'm here with my friend and former coworker, Dan Short, and let's get started. So Dan, how's it going?
Is going great. It's finally below 60 degrees, and that makes me happy because I live in a swamp.
Yeah, so and for anyone listening, Dan's over in Gainesville, Florida, and I'm in San Diego, so slightly different climates.
A little bit.
Just
a little bit.
So Dan, since we're talking about the McDonald's coffee case, why don't I kind of start off with you? I know that you've worked with me in law firms as a kind of file clerk and paralegal. You've done legal work with me, but probably don't know a lot about the McDonald's coffee case. So just to get us started, when you hear the McDonald's coffee case, what do you think of?
The big things that jump out were that a lady spilled coffee on herself and got a whole bunch of money out of McDonald's for it.
Yeah.
And that's kind of it. And that's beyond that, I don't know much.
Yeah, and that's fair. And it depends how you look at it. It's not entirely wrong. The problem is what most people's takeaway from that is that spilling coffee equaled an enormous amount of money. And what they don't realize is there was a lot of other things that were going on with this case. So first of all, this case happened back in 1992. And it involved a 79-year-old woman named Stella Liebeck who bought a cup of coffee. She was sitting in the passenger seat of a car at McDonald's. They had picked up the coffee from a drive-thru in McDonald's in Albuquerque, New Mexico. The driver of the car parked over in the parking lot so that she could open the lid to pour some cream and sugar into her coffee. And when she went to pour cream and sugar into her coffee, she put the coffee between her legs, it spilled into her lap, and it hospitalized her with third-degree burns to her inner thighs and genitalia. So that last piece might be news to you, depending on whether or not you've...
Yeah.
Yeah.
I don't wish that upon anyone.
Yeah. And one of the things that I don't think people realize is when you say third-degree burns to a 79-year-old woman, this is not a minor thing.
No, it's not like you get old people, skin thins out some anyway, and it's not difficult to have, a minor burn, let alone something that's going to have tissue damage,
Yeah, and third-degree burns, which are the most severe burns possible, they can burn all the way through the muscle and even into the bone. So these are massive burns. This is a podcast. Honestly, if we were doing this on YouTube and I were to show you pictures of what it actually looked like, I don't know that YouTube would let me publish it. It's pretty horrific.
Probably not. I remember from old EMT stuff, seen it. It's not pretty.
Yeah. Yeah, it's and also when I say genitalia, it's her lady parts, and without trying to be graphic, essentially it fused them. She required skin grafts, so she needed surgery, and she was actually told by her doctors there was a risk she was going to die. This was a massive, massive injury. And when it came to the trial, a lot of times people are starting to get a little more savvy that the things reported in the news are not necessarily what the jury actually heard at trial. But this is a case that is probably one of the more extreme cases of the way things got reported versus what the jury actually saw and heard are very, very different. So the jury not only saw these massive burns, but her doctor got up on the stand and said, both doctors and nurses were offering testimony that her injuries were some of the worst they'd ever seen. So keep in mind, these are doctors that deal with severe burns, and you have a 79-year-old woman with some of the worst burns they'd ever seen in their career. So what happened was the jury was treated to McDonald's defense, which the standard insurance company playbook for how to defend against a severe injury is, first what you do is you try to deflect. You say, well, maybe it was her fault. And this is what it's in California, we have something called comparative negligence, where what you can do is you can break down the percentage of blame. So if it was somewhat her fault and somewhat McDonald's fault, the jury can apportion it out by percentages, so that if, let's say that she got $1 million, but it was 40% her fault, then 40% of that $400,000 would be knocked off the amount that she recovered. So that's one thing that insurance companies will often focus on, is focus it on, I guess I should say, first they'll say, are we even liable? Is there any way this is even our fault? And they definitely got into that in the McDonald's case. But they also said maybe these burns were her fault, or at least partially her fault. And they did that through a mixture of saying, not only should you not have spilled it on yourself, which to some extent makes sense. Nobody wants to spill coffee on themselves, and that probably does require a little bit of not paying attention. But also, they suggested that maybe it soaked into her pants. She was wearing sweatpants, and that might have caused her skin to cook harder and harder. And this is where they say you should have mitigated your damages. You should have done something to prevent this ongoing burn from happening. And this leads to the somewhat absurd argument, which is you should have taken your pants off as soon as you possibly could.
Yeah, because 80-year-old lady's just going to jump up and drop trow real quick while she's burning.
While she's getting third-degree burns, yeah. And it's kind of I mean, we all learn to stop, drop, and roll, and we all hope that if we're on fire, that we'll have the presence of mind to do that. But to suggest that an old woman who's burning at her legs and is in a car where she's picking up coffee at a drive-through, it's an argument that makes a lot of sense from a defense perspective, because you want to find a way to put the blame onto her, but it also can backfire. Because
at the same time, like, if you spill coffee in your lap and you continue to spill it because you're melting yourself, you're going to be you're sitting in a puddle of burning coffee.
Yeah.
I mean, you can't get away from that unless you're leaving the vehicle. And if you can't get up because you're burning yourself and you don't have the, old lady muscle capability of just jumping right up, it seems kind of like a dumb argument from them.
Yeah, and it's one of those things where it was part of an overall theme. So what you'll usually see in a case, especially a personal injury case, is the insurance company is on the other side of the case. What they'll do is they'll start off by saying, this isn't our fault. This isn't our fault at all. It's 100% your fault. We did nothing wrong. And then if that, or I shouldn't say then if that doesn't work, but if they decide to concede liability because it's obviously their fault. So let me give you a simple example. If you're in a car accident case and somebody hits you from behind when you're at a stoplight, it's hard for it to be your fault, right? It's somebody hit you. So in those cases, the insurance companies might just concede liability because they don't want to make a terrible argument to the jury. But then they're kind of stuck with step two, which is comparative negligence, which is, let's see if we can say that it was kind of your fault. And then you get into the, if it was not kind of your fault, then you get into the, okay, you're exaggerating how bad it was. It wasn't that big a deal. So getting back to the first part of that, though, the, hey, it's not our fault. What they argued, and this argument makes sense at first, and that's that you should have known that coffee's hot. Everyone knows coffee's hot. Coffee's served hot.
How
What
hot?
what most people don't realize is if you were to go into Starbucks right now and buy a coffee and they just pour you a coffee, hand you a grande, that grande is going to probably be between 150 and 170 degrees Fahrenheit. What she got her coffee at, and actually what McDonald's had an internal memo for their franchisees to serve the coffee at, was closer to 190 degrees. And that difference between 150 to 170 and all the way up to 190 can be substantial. Uh, for anyone who might be listening and doesn't use freedom units and uses Celsius, 190 degrees is almost boiling. It's pretty much boiling. Boiling is 212 in Fahrenheit, but 190 is
That's the
essentially,
temperature that you pull a shot of espresso at.
yeah. And no one puts their hand under that as you're pulling the espresso. Nobody, wants to grab right in there. And it's actually one of McDonald's own quality assurance managers testified on the stand that at 190 degrees, the coffee was not safe for human consumption.
No.
Meaning, yeah. So meaning that when you get your coffee, you're not supposed to drink it. There was a reason for this, though, and there actually was a business reason for it. And it was McDonald's, if they're handing you coffee at a drive-through, they assume that you're driving to work. And people like hot coffee at work. So McDonald's made the business calculation of, well, you probably won't be drinking it right on the spot, especially because you're going to want to put cream and sugar in it for a lot of people. And so what they'll do is they'll put it in, they'll put it over to the side, put it in a cup holder, and then they'll just drive straight over. And then when they get to work, it'll be about 150 to 170 degrees, like you would get your Starbucks coffee today.
The optimal flavor temperatures.
Yeah. And by the way, I should probably point out, this podcast is not sponsored by Starbucks.
We're just coffee nerds.
We're just coffee nerds, and yeah, but pretty much all coffee today is served at about 150 to 170, and 170 being on the high end. That's usually not where you're going to get it. But for McDonald's in Albuquerque, and actually in a lot of locations, they were serving it hotter on purpose, knowing that it was essentially boiling. And at trial, the jury found out that over 700 people had reported that they'd received severe burns. So if you think about it from a jury's perspective, they're hearing that your coffee's hotter than anyone would ever be able to drink it. You're handing it to somebody in a drive-through. So, think about that. Think about how you've got your hands on the wheel. If you ever have felt how cluttered it is to grab things, especially if you're at McDonald's and you've got some 15-year-old handing you fries and a Big Mac or whatever else that you ordered.
Yeah, I was going to say the teenager that's handing the boiling coffee through the window, I'm not going to trust too much.
Yeah. And the thing is imagine if, I don't know if this would be safe to drive this way because everyone has car seats, but if you think about remember when you used to see kids strapped to the front of a mother, where they just have the baby strapped to their front. I haven't seen it too much recently. It might still be a thing. I haven't seen it too much in Southern California, but imagine if you've got some 15-year-old handing coffee to you, whether you're at the front counter or at the drive-through.
And they spill all over your baby vest instead.
Yeah, and all over your infant's face. We were talking about 79-year-old skin being extremely sensitive. That's same thing with little babies. So, the jury is basically hearing how and imagining how horrific this would be if some kid who's making minimum wage accidentally doesn't put the lid on firm enough and it spills. And chances are good it's some point in your life, and I know I've had this happen, you'll order a coffee and you'll reach over and grab it by the lid and the lid will pop off, right? And it'll spill on you. If it's 190 degrees, it's going to cook you.
You're having a bad time.
Yeah. You're having a really, really bad time. And not to mention if you're in a car and you spill that kind of temperature and you're driving, You're making it not just dangerous for yourself, but anyone else on the road as you're swerving in pain and trying to get over. So the jury's hearing all this and they're seeing the catastrophic injuries. But another thing that was going on, and this is something that kind of has to do with the way that a trial just flows. So as far as I know in California, and I assume in every state, though I guess I don't really know for sure, the way it works is the plaintiff goes first. And first what they do is they put the plaintiff and their witnesses up. And then usually, though they don't technically have to do it this way, they wrap up with their experts. They have their experts get up and testify about what happened. And then the defense gets to put on their defense. And they have their people come up, and then they have their experts. The thing is, with something where there's severe injuries, the jury ends up hearing from the plaintiff side's experts, and they end up hearing from the defense side's experts. And because of the nature of the way that evidence gets introduced into a trial, the experts might be telling the jury two completely different things, and at least one of them is completely full of it and is spewing massive amounts of junk science that the jury may or may not be able to detect. So in this case, and I should point out, these experts are paid a lot too. So experts on a case like this might get anywhere between $500 to $1,000 an hour. And it's not just the time they're testifying up on the stand. It's the time that they're having their deposition taken. It's the time that they're reviewing documents and they're performing, writing up a report for evidence to be introduced or discussed to the report. So they're making a lot of money on these cases.
Make up junk science for some money.
Yeah. And usually what it is it's somebody. This, believe it or not, the standard's pretty low. For example, in California, you essentially just have to be an expert in the field. You don't even really need to be saying something that is scientifically accepted. There's a slightly higher, though I could get into it, but not that much higher test in federal court called the Daubert test. But at the end of the day, what happened in this case was you have the plaintiffs who said with absolute certainty that this was 190 degree temperature and that it could severely cook her skin. And based on the injuries, that made a lot of sense to the jury. Yeah, it did. And then what you have is you have the insurance companies experts who are also getting paid a lot of money, who have to come up with a way to say, no, this shouldn't have happened. And that's also where, when we get back to the defense arguments of it must be somewhat your fault. You must have let it soak into your pants. And here's the thing with this. These experts, so this case happened in 1992. I don't know if you know this, Dan, but you and I actually saw one of these experts again in a case we worked on, I think in 2010 or 2011. One of the the expert, and actually it happened to be the expert for the plaintiffs. We actually had in a case where we were at the time working in an insurance defense firm, and it was the exact same expert testifying about something else. So these experts, really, they've made a career out of being experts. And especially when it comes to the experts that the insurance companies are picking, they're finding people based on how convincing they sound. Because essentially the jury is told, you figure out what the science is. And unless they're scientists, they're probably going to go with the expert who sounds like they're making more sense. And in this case, you have one expert saying, this definitely could severely burn her, which it did. So that makes sense. And you have the other expert saying, no, this doesn't make any sense, which is awkward because she got severely burned. And the thing is, what were you going to say?
I was just going to ask, so with experts, is it the hypothetical nature of what they're doing that kind of protects them from lying on the stand? Or, I mean, if they're just making up, if they're making up the science or the scenario to fit the person paying them. I mean, where does truth end up having to come into it?
So this is where the real problem is with this. There's really no consequences. Theoretically, if you're, for example, a doctor, a medical doctor, and I hate to say it, but doctors also make a fortune becoming, there are doctors out there who make a fortune just becoming experts and just testifying over and over again. And insurance companies know who to hire, who tends to say the things that they like to hear. And what the problem is theoretically, the medical board could go after them. I don't know that it's ever happened, at least for testifying. There's something that you probably have heard about, and this is a discussion for another time, but one doctor famously got something published in the Lancet where he said vaccines cause autism. A lot of people don't know that he was actually working with an attorney who was suing pharmaceutical companies. So what he was almost certainly trying to do was get published in a major journal so that he could then testify as the expert, not just in that case, but in every single case for suing vaccine manufacturers in all 50 states.
Easy to be the go-to guy if nobody else has published it.
Yeah. Yeah. And if you do well in front of a jury and a jury believes you and believes that you're the expert in the field, yeah, you could easily make millions of dollars a year testifying over and over and over again. And, I hate to say it as somebody who's plaintiff side, and used to be insurance defense side, but both sides have their experts. And I personally won't work with an expert that I think is spewing junk science, but there are attorneys who will, and certainly the insurance companies have no problem with it. So it's kind of this, it's a longer conversation for another time, because in this case, what's happening is you've got experts making comments about how, the physics of heated liquid, but then they take it to an absurdity where they start making generalizations about biological systems. And this is a massive problem. This is something that happens. I've seen it happen in several trials that I've been in, where what ends up happening is one expert makes some simple calculation. It could be like a high school physics level calculation. Like you'll see something along the lines of, let's say you're in a car accident case, and you'll have an expert who will actually testify that the car collision, based on their analysis of the change in velocity, you'll hear them say the delta V. The delta V was such that I determined that the kinetic energy was only something like 1,600 joules. And 1,600 joules, that's like 2 bumper cars getting into a head-on collision, which is technically right. But if you have an engineering degree or even just a pretty good understanding of high school physics, you want to scream whenever you hear an expert testify, because it has nothing to do with how much kinetic energy you have, anywhere near as much as how that energy actually transfers into the biological system. So, for example, I said that was 1,600 joules. I just happen to know this because I looked it up a while ago. Do you know what the hardest punch that Mike Tyson has ever been recorded as throwing with bare knuckle punch? You know how much kinetic energy was behind that punch? Any idea?
No idea.
1,600 joules.
Oh, okay. So a bumper car.
So a bumper car.
Totally not that bad.
Yep. Getting punched in the face by the hardest punch ever recorded from Mike Tyson. Bare knuckle punch to the face. That's a bumper car. Except that it's not. It's the way in which the energy transfers. And of course, getting punched on the shoulder is going to be very different from being punched squarely in the nose, or anywhere else, right? You have a biological system. So the way in which the energy transfers is going to be really important. You might know where I'm going next with this, Dan, because I know you're firearm enthusiast, but do you have any idea what the kinetic energy of a 9mm bullet is if it's fired at point blank range into someone's head?
In science terms,
Mm-hmm.
600 to 700 joules, depending on your grain count.
Yeah. Yeah, about that. I mean, it could be as low as 400, but 400, 700, 800 on the high end. Yeah, because all it is it's a function of mass and velocity. So depending on the muzzle velocity, depending on the mass of your bullet, like, 9mm generally are the same bullet mass, but could be a little.
700 joules at something very, very much smaller than a fist, though. It's going to do a different kind of damage.
Yeah. Yeah, and so you're talking half a bumper car if it's told to you by an expert. It's very easy to just tweak the numbers to be wildly misleading to a jury. But yeah, of course, if you'd much rather be hit by a bumper car or be in a head-on collision with a bumper car than get shot in the head by a bullet or get punched in the head by Mike Tyson. So anyway, I know we got a little bit off track here, but it's the same thing that happened in this case. You have two experts telling the jury, one expert saying, yeah, you're going to get third-degree burns when you spill this on human flesh. Well, sort of. I mean, if it splashed off the back of her hand, probably would have been a very, very different outcome. On the other hand, you have somebody who says this doesn't make any sense unless it's soaked into your pants and it's just cooked for a long time. Also probably wrong, because the temperature of a liquid probably drops quickly depending on what it's poured into. And this is where it gets really tricky to figure out how fast the temperature might have declined, because it probably wasn't cooking away for more than a few seconds. Maybe 10 seconds at the most is probably where it was doing the most damage. So anyway, I know we kind of got into the science nerd in me. I used to be an engineer, and it always drives me nuts when I hear experts. Nobody can see that I'm putting air quotes around experts, but experts getting up on the stand and opining that something is massively dangerous, and then the other person saying not dangerous at all. But either way, in this case, what happened was you had somebody who was so severely injured that the jury looked at it and said, yeah, this is something where, and McDonald's knew because they'd seen hundreds and hundreds of injuries, where they said, yeah, you need to not only be awarded for your pain and suffering, but you also, we're going to award what are called punitive damages, where you punish the company. And it's specifically designed to punish the company. So now we get into the numbers you've probably heard about, but probably also get wrong. Do you know what she was awarded in this case?
I thought it was like 2.7 or 3 million, something like that.
Yeah. So sort of. Yeah, you hear. So if you heard from the news, you probably heard woman spills coffee, gets $3 million, and that's wrong. What it was she was awarded $160,000 for medical bills and pain and suffering. And the jury also decided to punish McDonald's with 2 days worth of their coffee sales, which worked out to 2.7 million.
2 whole days, because that'll deter them.
Yeah, exactly. So it was made out to be this ridiculous, over the top punitive damages award, like just completely outrageous. And it was just 2 days. And that's how they came to their calculation, is they looked at it and said, yeah, that 2 days, we'll punish McDonald's 2 days of coffee sales. Here's the thing, though. The punitive damages number was immediately reduced by 80% by the court in Albuquerque. And courts have, even back in 1992, they had a lot of discretion to reduce punitive damages. They have not just discretion, but they're required by law to reduce punitive damages in many situations now. So what happens is you get the headline that says 3 million, but really her punitive damages, this is instantly. The jury comes back with their award, and instantly they were reduced to 480,000. So 160,000 for pain and suffering for something that destroyed her genitalia and destroyed her thighs, and gave her all the pain and suffering and hospitalization and almost killed her. and required surgery. She got 160 grand for that, and McDonald's was punished 480,000. But we're not done.
Well, before we move on though, would the
Yeah.
risk there, had the like 2.7 million stood, just be that it's going to be immediately appealed and then stuck for years in other courts, and then she gets nothing?
Yeah. Um, and also no. So to her, yes. So if you're her attorney and you get a $2.7 million punitive award that is instantly reduced to 480, and she gets 160,000 for pain and suffering and for her medical bills. By the way, I should point out 1992 medical bills, a bit higher now, but still 160,000 and 480. So it's at 640,000. Immediately, McDonald's has the opportunity to, and definitely was going to take it up on appeal. So that could hold it up for quite some time. If you're in California, you can get 10% interest. I don't actually know what it is in New Mexico, but it's so if you win, yeah, you'll get your interest. And depending on the situation you're in, you might actually get more money. If you lose, you get another trial. And again, depending on different things. Sometimes the appellate court will give instructions to the judge to change the number or do something else. But as a general rule, yeah, you could be stuck doing this case all over again. You could be stuck just not getting paid for a long time. McDonald's is probably not going to run out of money, but if it was a company that could go bankrupt, they could file for bankruptcy and you might get nothing. And keep in mind, she was 79 years old. So, by the time she actually would have seen this money, she could be well into her 80s, which might mean, especially given that she had severe injuries, she might not be around anymore.
Yeah, I was gonna say,
So
didn't she die a few years after?
I think so. I actually don't know when she passed away, but, she certainly was an elderly woman. And you can imagine that if you're her attorney, you're telling her, hey, we need to settle this thing. And I think it was settled for an undisclosed amount that is assumed to be somewhere between 400 and 500,000. But here's the thing. If I were to ask you, Dan, would you be willing to let me dump boiling hot liquid into your lap that will hospitalize and possibly kill you and destroy your genitalia? But in exchange for that, in a couple of years, you'll have an opportunity to get put up on trial, told that it was your fault that this happened, and then maybe get a few $100,000. Would you be willing to do that?
That's a immediate no.
Yeah. So absolutely not. No one would. And I
Maybe
mean,
like on my foot.
yeah, maybe on your foot.
Maybe.
Although it sounds good until the boiling water is right above your foot. But yeah. Yeah, I mean, that's the thing, is that this was something that she was in an incredibly awful situation. And it was immediately she became a national pariah. She was made fun of on talk radio, on talk shows, late night talk shows. So you're putting yourself out there, and even winning, you end up not getting that much. And I'm not even getting into what are attorneys and what all. Remember when I said those experts cost money? Yeah, they got to get paid out of whatever you won. So there's no way that she walked away from this with more than a couple $100,000. And what she had to go through and how badly she had to suffer. This is a case that a lot of people got completely wrong. But there's other things going on here. When I said to you just a minute ago, when you asked me if it was just about this case and about the 3 million, and that would be, just go get it tied up in appeals. From the defense perspective, that's not what their fear is. Because, yeah, they can tie this case up for a long time, or they could just pay her off and settle it. In fact, even if they just paid, the amount that the court awarded, 480,000 in punitives plus 160,000 in pain and suffering, even that's not a big deal. Certainly not to McDonald's. I mean, 2 days of coffee sales is 2.7 million. But it's not just this case that they're worried about.
It's the precedent.
Yeah, it's not just McDonald's, because McDonald's almost certainly had insurance covering this full amount. I tried to find out the actual insurance policy on this, and I was having trouble. I was trying to dig into it, but
That
something
would
that
be interesting. What the policy limit for something like this might have been.
yeah, I can tell you from my own experience working, in-house at companies, is it was probably many millions of dollars. They probably have plenty of probably McDonald's likely has an enormous policy. With a lot of it's probably really complex, but at at the end of the day, um, there was it does appear that there was insurance on this case, and they probably covered everything. And insurance companies, we'll get into this. I think in probably part two. I think we'll have to break this out to talk about something that every lawyer knows, but a lot of people don't realize. Insurance is involved in a lot of cases, especially personal injury. Almost every personal injury case, insurance is going to be involved, but they're involved in a lot of different types of cases. And insurance is not worried about the one case. What they're worried about is that word gets out that, if 700 people are getting severe injuries and reporting them, how many other people are getting injured and not reporting them? And insurance doesn't just insure McDonald's, they insure everyone who serves hot liquid, right? So everyone who serves tea and coffee. So anyone else out there who's serving their coffee at an extremely hot temperature, insurance companies are going to get nervous that when people find out about the award, which of course they're going to find out because it makes headlines. The insurance companies are terrified that you're going to have hundreds and hundreds and hundreds of lawsuits all across the country, because now they have to pay out not just on this case, but on however many cases pop up everywhere. And so they wanted to make it as much Miss Liebeck's fault as they possibly could. They wanted to blame her. So that's really where kind of the background, what was going on here and why there was such a push to put the blame onto her. The other thing that I probably should mention about this is, so insurance is not an industry that most Americans realize. In fact, even attorneys, it's way bigger than people think. A lot of times we just pay insurance and don't think anything about it. You pay your car insurance because you're required by law to have car insurance if you have a car. You're required to have health insurance now. Most professionals are required to have insurance, malpractice insurance, doctors, lawyers. The thing is, the insurance industry is so huge and powerful in the United States that you measure it in trillions. It's an industry that is worth over $1 trillion. So with a T. So they're one of the biggest and most powerful industries in the United States. And because they're so intimately involved in lawsuits all across the country, and I mean thousands and thousands and thousands of lawsuits in every single state, they have a huge interest in trying to control the narrative and make sure that jurors think that certain amounts of money are too much because they don't want to have to pay out whenever they lose. So that's the bigger thing that was happening here. And I think we should probably stop right around here, because what I want to get into in the next podcast is just how much the insurance industry controls litigation and how much is going on in the background that even attorneys usually don't know. Even insurance defense attorneys, which I did for a decade, don't necessarily realize just how much pull the insurance companies have, because they are involved at every step of the process from the very, very beginning when you first make a claim. And in this case, Miss Liebeck initially just made a claim for, I think it was $20,000, because she just wanted her medical bills to be paid. And the insurance company would have jumped in right at the beginning of that. And they are with it all the way up until the trial, through appeal, back to another trial, in that case and every other case like it, which is why, as I was mentioning earlier, everything from the experts who make a career out of working for insurance companies is a huge industry that people don't know exists, unless you're a lawyer and you come across it. And it's why this industry reacted and kind of used this as very much a case where they decided we're going to make an example out of her and try to humiliate her and try to make it seem like America's verdicts are completely out of control because we've got billions and billions of dollars on the line and we have massive, massive incentive. And we'll get into this. They also have a lot of political pull because they're huge donors to politicians all across the United States. So the lawmakers who are making the laws are making them with insurance companies in mind. So we'll get into all that in the next podcast, but I think it's a good place to stop. So thanks, everyone.
Learned a bunch.
Yeah. So with that being said, thank you all for listening. And I hope that all of you will join me in the next one. Bye.